All right, picture this. Senator John Kennedy, sharp as ever, sits across from 7th Circuit nominee Rebecca Taibleson in the Senate Judiciary Committee. Kennedy leans in, that signature Louisiana drawl, and says, look, passing a bill isn't just about a vote. There are debates, reports, behind-the-scenes wrangling, the whole package. So why, he asks, do judges ignore all that context when it's time to interpret a law? Taibleson doesn't flinch. She says, the text is king. That's what Congress votes on. That's what the president signs. Sure, legislative history, those debates and committee reports can sometimes help, but only as a backup.
Counselor, as you know, it's hard to pass a bill in the United States Senate. Our founders intended that to be the case, and consequently, if a bill does pass, it's gone through a long, arduous process. A lot of reports issued, a lot of debate, and all of it's written down. Why has it become common practice, and do you support it, of ignoring that rich legislative history when you interpret a statute?
Well, Senator, I think the first rule of statutory interpretation is that the text is what's paramount. And that's because the text is what actually proceeded through bicameralism and presentment, which are really just the fancy.
Of course, it's paramount, but why can't the text be supplemented by looking at the history?
I think the legislative history can sometimes provide a tool to help interpret the text. And it's often in parties' briefs, and I would, of course, consider it that way. But it's just important to keep in mind its subordinated role in that interpretation, because the intention of any particular legislator does not have the force of law. Instead, the text does. So the legislative history and the intentions of specific legislators should never take primacy over the text or refute the text.
Now, Kennedy isn't letting this go. He presses, doesn't history help make sense of things? Isn't it risky to ignore what Congress actually meant? Taibleson nods. Yeah, sometimes context matters, but she's firm. You can't let old debates override what the law actually says. Kennedy tries to paint it his way. Looking at legislative history is like taking a peek just to make sure you're not out in left field.
Doesn't have to, does it, Counselor? It just gives you context.
I agree with that.
When you interpret a statute or write a brief and you think that the language is plain, aren't you tempted to go look at the history just to make sure that your interpretation is correct?
It depends, I suppose, on the particular statute and the nature of the history at issue and the question.
But don't you want to just go take a peek? You look at the language and you say, well, this is as clear as thunder on a summer night. But maybe I'll just take a peek at the legislative history to make sure that I'm not out in left field. And the Supreme Court condemns that, does it not?
The Supreme Court does not uniformly condemn that, and there are certainly cases where, legislative history or statutory history has provided a tool.
Sure they do. I mean, originalism, and I'm not saying they're wrong. Please don't misunderstand me. I'm just trying to understand your perspective. Originalism and textualism is accepted even by the left of center justices. And I've read opinion after opinion, lower courts as well, where they say, well, legislative history, we can't rely on it.
Legislative history cannot be relied upon to trump the language of a statute. And so when the language of a statute really is that clear, Senator, there's not that much, and it bears directly on the question before the court.
Quick pause. If you're into these tense Capitol Hill moments, make sure to hit that subscribe. You don't want to miss what's next. Back to the action. Kennedy shifts gears. If legislative history's off limits, why does the Supreme Court use the Federalist Papers for the Constitution? Isn't that legislative history too? Tableson's ready. The Constitution, she argues, is different. The Federalist and Anti-Federalist Papers were part of a public debate about what the Constitution should mean. That's not just a few lawmakers talking, it's the whole country.
Well, let me ask you something. Does the Supreme Court sanction looking to the Federalist Papers and interpreting the Constitution?
Yes.
Why isn't that legislative history?
The process for ratifying the Constitution is, of course, different than the bicameralism and presentment process that applies to statutory text. The Constitution was, of course, publicly ratified.
No, it's not.
Well,
you look at the plain language, don't you?
Yes. But in looking at the plain language, the question we ask is, what was the original public meaning of that language? And in the case of the Constitution, the original public meaning is elucidated by the debates surrounding its ratification. And those debates are really captured in the Federalist Papers, the Anti-Federalist Papers, the ratification debates, the notes from the Constitutional Convention, documents like that. So those documents can bear directly on the constitutional text in a way that is more legitimate necessarily than the, statement of an individual legislator would be vis-a-vis a statute.
Well, then,
Final round, Kennedy asks, if judging the law is all about history, why not just hire history professors instead of judges? Taibleson draws her line. Judges don't just read history. They connect the past to today's cases. That's legal reasoning, a judge's job, not just a historian's.
then when we interpret the United States Constitution, and I agree with you, that's the case. I'm just asking you, what do you think it ought to be the case? Then when we interpret the United States Constitution, why do we let lawyers do it? Why don't we just hire history professors?
The history that judges are looking to in interpreting the Constitution and other statutes is primarily legal history. It's not something like, a biography of George Washington. It's instead things like statutes or, debates about statutes, the Federalist Papers. And certainly, I think law schools could do a better job and should do a better job, teaching students how to read that legal history. But it is fundamentally legal history. And then the task the judges have in reading that legal history is to draw analogies between that legal history and our modern times. And that analogical reasoning is, I think, a fundamentally lawyerly task the judges are particularly skilled at.
Thank you, Mr. Chairman.
So here's the real question. Should judges stick strictly to the words of the law or peek at the history for context? Kennedy wants a balance. Tableson's all about the text. Where do you land? Let us know below. And don't forget, like, subscribe, and ring that bell for more no-nonsense breakdowns, right here on Congress Unpacked.